Now, let's take a look at some stories from home, where Chief Justice of Nigeria, that's Justice Olukayode Ariwola, is advocating alternative dispute resolution instruments so as to free the courts from what he described as unnecessary cases, which, according to him, overstretch the judiciary. Ariwola, while urging Nigerians to be less litigious, reminded the public that there must always be a winner and a loser after every legal firework. He said Nigeria could not import foreign laws to try local cases, as some litigants would erroneously and desperately want the court to do in the quest to get victory. Well, his statement was response to an apparent reference to the last presidential election litigation, where the opposition parties used evidence from courts in the United States to challenge President Bola Tinubu's qualification to vie for the presidency. The CJN said he would do everything possible to ensure that the apex court attained its full complement of 21 justices before retiring next year. Well, Rise analyst Dayo Sobowale is joining us now for a conversation on the concerns in the litigation process as expressed by the Chief Justice. Good afternoon. Great to have you on Newsday as always.
Pleasure being as usual.
Right. We don't have much time, so let's get straight into it. A lot was said. It was a very information-packed speech by the CJN. What were your major takeaways?
Yes, he's trying to say that Nigerians generally are very litigious, especially when it comes to political cases. But they do not have the spirit of sportsmanship. That people should be able to accept the verdict of the judges, even though they have a right to go on. But invariably, they go on to the Supreme Court, which is the final arbiter. But that the judges are stressed. So it's like saying that the demand for justice is far in excess of the supply. That is quality supply from the judiciary. And it's right to say that because they are human beings. But the fact remains that it is the judiciary itself who can do the reform that is advocating about. Like the last judge of the Supreme Court that criticized the way the Supreme Court is structured. If you look at it, people took that to attack this present CJN. But what that judge was saying, the retired judge, was saying that there was no delegation of responsibility. Because the CJN, like now he said, they will make sure they appoint Supreme Court judges to fill the bench before he leaves. He's the chairman of that panel. Judicial reform and every other thing is the chairman. But that is the structure. You get me? The judge who said that was trying to make it look as if it was personal to this CJN. But that is their structure. And they must have their own reason. You don't just delegate responsibility just for the sake of it. There must be need for it. If you are overstretched, maybe that the reform should even start from that. That the CJN should not be overburdened. Just like he has seen downstairs that the judges too are overburdened. But I like the way he said it. He said some cases should even stop at the Court of Appeal because there are competent judges there, not necessarily going to the Supreme Court. But then, you see, the judiciary, I do not envy them now. They have a poor reputation. Even though I admire him, the way he has been admonishing judges when the Supreme Court judges were, Court of Appeal judges were appointed, he told them to be upright, to be neutral, to be truthful, so that they can rest well in their houses. The same thing when he spoke to these senior advocates of Nigeria. You see, I think the problem is not with the Nigerian litigants or the litigious tendencies of Nigerians, but it's between the bar and the bench. And it is their territory. The Supreme Court is the Santorium of dispensation of justice, but see what happened in Kano. Yeah. It is heresy of the worst order. Even a judge in the papers today said you could now which one is authentic, now know or distinguish between what is authentic, between the utterances in court and the certified true copy. You see, that is a great dilemma that questions the integrity and professionalism and the intellectual capacity of the judiciary.
Very well said, Mr. Sobowale. But when you look at the what was said by the CJN in this case, saying that,
or there should be alternative dispute resolution instruments.
Yes.
Does that send a wrong message, you think? Like maybe people might start to see that, okay, they might not get what they're seeking in the courts and then try to take matters into their own hands to get the outcomes that they prefer to. I mean in terms of how it might be interpreted, not what he said.
Yes. Alternative conflict resolution. It means you do not follow everything to the letter of the law. That is, you don't go through the entire gamut of the legal process. It's a time-saving thing too. It's a time-saving conflict resolving situation. That you don't need to go through the gamut of the entire process. That midway, the law or the legal process, somebody can intercede in the legal process and give you the justice that you are asking for. I do not see anything wrong with that. But what I am saying is that the reforms, you get me, or to make justice less expensive and to make the burden of dispensing justice not too burdensome on the judges, it is the bar and the bench that must come together. The Judicial Council is there to deal with judges, but the bar and the bench. You see, look at the way the cases spring up. You see sons on either side. And when the judgment is given, you see that it's as if they didn't go to law school the way they have presented it. You get me? And it is an open secret that Nigerian lawyers are so well paid that some of them are not be in the same country like ourselves. You get me? But if justice is expensive, and if some people can afford it, then the onus is on the legal system to curb itself of the attractiveness of litigations and prolongation of litigations, because that will make justice unaffordable in terms of time and money. Although, at the end of the day, the lawyers are the beneficiary of the litigation, because they run all the way to the bank, while the political system is structured in such a way to be against judges until they give verdicts that do not fit into what the particular politicians want.
Right.
Yes.
Well, Mr. Dayo Sobowale, on that very profound note, thank you so much for your input. We always value your analysis here on Newsday. Thank you very much.